All right, everyone, it is right on 2 o'clock here, so we're just going to go get started. I'm going to start with a little brief introduction, so feel free to get settled and check out the PowerPoint that I posted in the chat box that can be found on at the Dropbox link. Just want to thank everyone for joining us today. My name is Jay Fortune, and I'm the office manager here at Standpoint. My role today is just to help facilitate the webinar. If you have any questions during the presentation, please type your question in the Q&A tab, or you can use the chat box as well, and I'll pass the question along to our presenters. Most of you probably are already familiar with our organization already, but for those who don't know, who are watching us later on YouTube, Standpoint is a statewide organization. We're a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls to our action line. Examples of trainings we do are our annual new laws throughout the state of Minnesota, monthly webinars for advocates, and other trainings by request. Our action line is answered Monday through Friday from 9 to 4 p.m. It is through our action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources, safety plan, listen, and help callers identify possible options and next steps. This webinar is being recorded, and you can check it out on Standpoint's YouTube page. The link to the recording will also be emailed out to Standpoint's Legal Advocates listserv after the webinar. For today's presentation, I've put in the chat box a link, as mentioned before, so you can follow along there. And now I'm going to pass it off to Anne and Raelene for the presentation.
Awesome. Thanks, Jay. This is Raelene. I use she, her pronouns, and I am the housing advocate with Standpoint. And Anne is our housing attorney, and you'll be hearing lots from her today. We're going to talk a lot about eviction and what that looks like for advocates and how advocates can help in that process. The most important piece is how we can set victim survivors up for success. So we're talking about that today. Like Jay mentioned, please feel free to put questions in either the Q&A box or the chat box, and we will answer them throughout. All right, so kind of where are we headed today? We're going to talk a little bit about the eviction ban update. We have some, it's been, and I'll get into the details there. We'll talk through eviction basics, settlement agreements, and a post-eviction follow-up. And I think that this is really important information to advocates to be thinking about because, housing is something that's so important and vital to the work that we do. And evictions can be a traumatic process for people. They are, facing homelessness potentially. They're looking for new housing to go to, and they're just trying to make it through that eviction process. And oftentimes we know that victim survivors have been through a lot in addition to this potential eviction that they're facing. And it's really difficult to see beyond the immediacy of their situation. And that's where advocates can really come in and help think about some of the different steps that they can take during an eviction process that can help set them up for success and ultimately find safe and stable housing going forward is the ultimate goal. So we hope that this training will help kind of give an idea of what that looks like and how advocates can help.
So we will get started today talking about the COVID protections around eviction. Minnesota's eviction moratorium is still going strong. Governor Walz again extended the eviction ban, which currently runs through December 14. We refer to this as an eviction ban, but it's really more than that. A landlord is not allowed to terminate a tenancy for any reason, with a few narrow exceptions that we'll cover in the next slide. So at least for now, a landlord cannot give a notice of non-renewal or terminate a lease at the end of a lease term. They can't give a notice to vacate or a notice to terminate a lease on a month-to-month tenancy. They can't substantially increase rent or do anything else to try to get that tenant to move out. Of course, there are exceptions, and the exceptions to this eviction moratorium include, so landlords are required to file an eviction if a tenant engages in certain illegal activity on the premises, such as illegal use of controlled substances, prostitution-related activities, unlawful use or possession of a firearm, or possession of stolen property. This has been the law for a long time, that landlords have to evict people engaging in these behaviors, and these evictions are still required even with this eviction moratorium. Other exceptions to the eviction moratorium apply to breach of lease cases, including when a tenant seriously endangers the safety of others on the property, or when a tenant causes significant property damage. This exception could allow a landlord or homeowner to evict an abuser in a domestic violence situation, though getting the landlord to do so might be another problem. And of course, what qualifies as significant property damage is debatable, and it's going to depend on the facts of each specific case. Another exception for landlords, another exception is for landlords who need to move back into their property or who have family that needs to move into the property. These landlords can end a tenancy with appropriate notice. So for a tenant who has an annual lease, a landlord in this situation could give notice of non-renewal at the end of the lease term, but they have to follow that the notice provisions that are in the lease. So as an example, if a tenant signed a 1-year lease in March 2020, and that lease includes a 60-day notice provision, the landlord can give the notice or the tenant a notice of non-renewal with a move-out date of March 31st, 2021, which is the end of the agreed upon lease term. The notice would have to be given anytime before the end of January 2021 in order to follow the 60-day notice requirement that was written into the lease. For month-to-month tenancies where there's no set lease term, the landlord can give a 1-month notice to terminate the lease or a 1-month notice to vacate. In situations like these, if the tenant remains on the property past that move-out date, the landlord can then file an eviction with the court. So remember, these examples only apply to when the landlord or their family needs to move into the property. For all of these exceptions, the landlord must give a 7-day written notice of their intent to file an eviction to the tenant. That 7-day notice period, depending on the circumstances, can be good or bad for the people that you're working with. So this is a place where really careful safety planning is probably going to be important. We have the CARES Act. The CARES Act applies to federally funded properties, including public housing, Section 8, and any property with a mortgage backed by the federal government. So it really does apply to a lot of properties. The CARES Act included a provision banning eviction for non-payment of rent, but that provision expired in July. The CARES Act does continue to require a 30-day notice period before a landlord or property manager can file an eviction period. We also have the CDC order that prohibits evictions for all properties, both privately owned and federally funded. And this prohibits evictions for non-payment of rent only, and this goes through the end of the year. Because Minnesota provides greater protection than the CDC ban doesn't really apply to a lot of cases here in Minnesota.
All right. So during COVID times and thinking about housing, there are a few things that we can think about in terms of advocacy. So first and foremost, if you are working with someone who you think is facing an eviction that's not appropriate or not allowed during this eviction moratorium, you can access the Attorney General and file, you just kind of write a request to the Attorney General and they'll look into it further. The Attorney General is being pretty aggressive and looking into landlords and improper evictions. So it's really, really helpful and really easy to find on the Attorney General's website. As Anne mentioned, that 7-day notice with the intent to file an eviction can be a really important time to think about safety planning. Is the person safe staying in the home? Do they need to find somewhere else to go? What does that look like? And having really good conversation with someone about that safety planning can be super important. And then it can also be helpful to review someone's lease to determine if proper notice was given in terms of an eviction. And if you have questions about that, you're always welcome to reach out to Standpoint and we can look further into it.
Just one point of clarification, Raelene, the Attorney General has an online tenant eviction complaint form. So anyone that is working with anyone that's having trouble with the landlord trying to get them out, they can file this online complaint form, and the Attorney General is following up really quickly with that.
Yeah, and it's a pretty simple form, so really easily accessible. They don't ask tons and tons of questions. It's not like really cumbersome, so it can be really easy to fill out and do that with someone. So thanks for that clarification.
Mm-hmm. Okay, so let's talk about eviction. What exactly is an eviction? There's a surprising to me, probably not to everybody else. There's a lot of, question around this. An eviction, which is also referred to as an unlawful detainer or AUD, it's a specific legal process that requires action through court. So Minnesota law does not allow a landlord to remove a tenant from rental property without going through the court eviction process. Sometimes landlords will simply, tell a tenant to leave or change the locks or turn off utilities or do something else to sort of force a tenant to move out. This is sometimes referred to as self-help eviction, but in Minnesota law, this is really an unlawful lockout and it's not allowed. So if there hasn't not been court action, there really hasn't been an eviction. It's also important to note that an eviction action may or may not result in the tenant being removed from the property. Some people think that for an eviction to be on their record, they have to have been removed from the property, but that's not so. Many evictions end with a settlement agreement where the tenant remains in the property. That eviction, it's still an eviction and it's still on their record because it went through that court process. The eviction process in Minnesota moves quickly. A tenant can be removed from the rental property through an eviction in as little as 21 days. And that eviction goes on the tenant's record the day the landlord files the eviction with the court, and it remains on the tenant record until a judge orders it removed. So even in cases where maybe the eviction case was dismissed or the landlord withdrew their complaint, those remain as an eviction on that tenant's record. There are cases where the settlement agreement is reached and the tenant pays and stays on the property. Even in those cases, that eviction is still on the record. I've seen cases where the landlord will file an eviction with the court, and at this point, the tenant doesn't even know that it's been filed. But then they go and work out a payment plan with the tenant outside of court, and the landlord then cancels that eviction hearing, and that record stays on the court. So the eviction was still filed, it just shows that it was canceled. So the tenant still has that eviction record, eviction on their record. So I've worked with many tenants who were surprised to learn that they have an eviction record, either because they paid and stayed, or because they worked out some other kind of settlement agreement with their landlord, or maybe they didn't even know that one was filed to begin with. A lot of what we're talking about today is for when victim survivors are being evicted, but we've been getting a lot of calls lately from victim survivors who are on the other side of this discussion and who need their abuser to leave. In most of these cases, the caller, at least the cases that I'm dealing with and that the callers, here at Standpoint are calling about, the caller owns the home and it's their ex-partner or a friend or a guest. Someone had been living in the home for like an extended period of time. The relationship deteriorated and there's some abusive behavior involved, but not enough, nothing that rises to that level of obtaining an order for protection. These cases are tough. There may be ways to evict the abuser in these situations, but it is really complicated, even without these extra COVID restrictions. So if you're seeing this in your work, we definitely want you to get some legal advice that's really specific to the situation that you're working with. One thing a housing attorney would look at is whether there's a landlord-tenant relationship. And a lot of people are surprised to know or to learn that there doesn't need to be a specific agreement, either written or oral, to have a landlord-tenant relationship. The actions of the parties can imply a lease agreement or imply some kind of an agreement, which would then create that landlord-tenant relationship. So you think of cases where there's an agreement or an understanding that the roommate or partner or ex-partner, that they do something every month. Maybe they pay certain utility bills, or maybe they do certain work on the property, like yard work or shoveling the driveway. Maybe they buy all the groceries for the household, or maybe they contribute to the mortgage payment. These other agreements that a lot of people don't think of as, rent. So then they would think maybe there's not a landlord-tenant relationship. It's possible, it's even likely that these actions do create this landlord-tenant relationship. It's important to remember, even when there is no landlord-tenant relationship, the person living on the property likely has some legal protections. So the homeowner definitely should not take it upon themselves to remove someone from the home, like changing the locks or doing anything else that kind of forces the other person out. Because remember, we can't do self-help eviction in Minnesota. So if you're working with someone who's dealing with this, definitely give us a call. They're tough situations to work through. And sometimes, at least now with COVID, we don't have a lot of great answers, but there are some options. So definitely, give us a call and we'll see what we can do. So again, the eviction process moves quickly. So here we have an eviction timeline just to kind of give you an idea. On day one, the landlord files the eviction complaint with the court. The court will then schedule the hearing and issue a summons, and that summons orders the tenant to appear for that hearing. The eviction is now on the tenant's record, even though the tenant is probably not even aware that the eviction has been filed. Between days 1 and 7, the landlord must provide the tenant with a copy of the eviction summons and complaint. This is called service. In eviction, service is important, and we're going to take a look at that on the next slide. Between days 8 and 14, the eviction hearing will be held. According to Minnesota law, the eviction hearing must be held within 14 days of filing the case with the court. However, with the COVID restrictions, courts have more leeway with this timeline for scheduling hearings. This eviction hearing is actually an initial appearance. Most cases are resolved at the initial appearance. But for cases that require a trial, the court will often set a new date. But you have to be ready because the judge may choose to hold the trial at the time of that initial appearance. So tenants always need to be prepared to present any evidence that they might have anytime they go to court. Between day 14 and day 21, the tenant is removed from the property. So depending on the resolution of the case, the court may order that the tenant be removed from the property that same day of the hearing. So it can go pretty quick. So we're going to take just a little bit here to talk about service. Service of process is a legal term that describes how one party to a lawsuit has to give other parties notice, either that the lawsuit has begun or that the other party has filed something new with the court in an existing lawsuit. Minnesota law requires what we call strict compliance with the service laws for eviction actions. There are very detailed, specific rules for how the landlord must do service. One is that the service must be complete at least 7 days before the eviction hearing, and service must be done or performed by an uninterested party. So that party has to not be a party to the lawsuit, and they can't be, tied to the property. So the landlord or the property owner or the property manager, probably even a maintenance person, is not allowed to do service. There are 3 types of service for an eviction action: personal service, substitute service, and mail and post service. The landlord must at least attempt personal service. Personal service is when someone, the uninterested party, finds the tenant and hands the eviction summons and complaint directly to the tenant. With substitute service, the uninterested party can leave the eviction summons and complaint with a person of suitable age and discretion who lives with the tenant. So that's the language from the statute. Of course, what qualifies as suitable age and discretion depends on each specific situation. For example, if the person doing service knocks on the door and the 13-year-old child opens the door and accepts and receives service and gets the summons and the complaint, that probably would be considered someone of suitable age and discretion. If you had someone who maybe was 20 but there were some other kind of issues that made it so that they couldn't understand what was happening, then that might not be someone of suitable age and discretion. So it really just depends on each situation. One key thing here is that person who accepts the service has to live there. So service on a neighbor or a family member who might be visiting, or the babysitter, that all of that would be improper service. And when service is improper, the case should be dismissed. So that's why we're kind of going over this, is because service is important, and it could, improper service can result in getting the case dismissed. Mail and post service literally means the eviction summons and complaint will be both posted on the tenant's door and mailed to the tenant. With mail and post service, though, the landlord has to do a few things before mailing and posting, and this is kind of where mistakes happen. So having an attorney review how service happened for each case can be, can be really helpful. What we're trying to show here, is that service can be complicated, and when service is improper, the eviction case should be dismissed. So if you're working with victim survivors who are facing eviction, having that case reviewed by a lawyer who has access to court documents can be really beneficial. Some of the stuff that we're talking about here is kind of deep in the weeds with legal stuff. So if you guys have questions, definitely feel free to jump in as we go. I'm happy to stop where we're at and clarify things if needed. So let's think about legal defenses to an eviction action. There are many legal defenses to an eviction case, even in cases that seem like eviction is imminent, like non-payment of rent cases. There may be one or more valid defenses available that could result in either the reduction of the rent owed or the dismissal of the case. Knowing about potential legal defenses is really helpful for the tenant because it can provide leverage for the tenant as they're trying to negotiate settlements with their landlords. So again, it's important for victim survivors facing eviction to have their case reviewed by an attorney, and we're definitely here for that. So here's some examples of legal defenses are, like I said, improper service. In non-payment of rent cases, maybe the tenant paid, maybe there's an issue with late fees. So there's a statutory limit for late fees that we often see landlords exceed. If there's no written lease, then the landlord can't charge late fees, so that can provide a legal defense. Maybe there were improper utility charges, or maybe there are repair issues on the property, where tenants were charged for property damage, like for damage that was related to domestic or sexual violence, that can provide a legal defense to a non-payment of rent case. So there are a lot of different options. When we're looking at breach of lease cases, one thing that is important to know is that there has to be a written lease. So a landlord cannot evict someone for breach of lease if there's no written lease. And then in the cases where there is a written lease, that breach, whatever the alleged breach is, must be a material breach. So a landlord can't evict a tenant for a breach of a lease when the alleged breach is some kind of minor infraction that doesn't really have a big impact on the overall picture. Holdover cases are when the landlord has provided appropriate notice to terminate a tenancy and the tenant doesn't move by that move out date. So we call those holdover cases. Some defenses there include retaliation, invalid notice, or depending on the situation, when a landlord accepts rent payment for the month after the end date given in that notice to terminate the tenancy. The big takeaway here is even in cases where it seems like there's nothing the tenant can do to avoid or postpone eviction, there may be options. There are other legal defenses. I just kind of wanted to give a brief overview here. So keep that in mind as you're helping people with their eviction work.
And we've got a question. In breach of lease cases, how do you know if the breach is considered material?
Yeah, that's an issue of fact. And it would be ultimately it's up to the judge, right? So if let's see, an example of a breach of lease that would not be material maybe is like a one-time noise complaint. Maybe a tenant had too many people over or had the music up really loud, but it was just one time. You know, that might not rise to that level of a material breach, but maybe the tenant had a week-long party or was doing it regularly, right? Then that might rise to that level of material breach. If maybe, you know, property damage, if there's some kind of extreme property damage, that could rise to the level of material breach. But of course, you know, so the answer is that is an issue of fact that the judge decides, you know, and if you're working with that, you'd want to talk with a lawyer to see what kind of arguments can be made, you know, to try to argue that it was not a material breach.
All right, so thanks for that big overview of eviction stuff, Anne. I think that that's really important for us as advocates to know and have at least a general basic understanding of how that process works. As you talked about, the eviction process is super fast. And I think that's where advocates can be super helpful in, again, setting people up for success. So if you, I will always argue that if you're working with a victim survivor, you should find out about their housing situation, because if they are facing eviction, that process is super, super fast. So connecting them up with resources and attorneys and digging into that as soon as you can is really helpful. If someone has received notice that they're facing eviction, it can be really, really important to contact the court to find out when and how the hearing will happen. I think especially right now, oftentimes the summons are not always correct and things are changing a lot. So making sure that you are contacting the court to find out when and how someone should appear, whether that's over Zoom or in person, what room are you going to, because that there's a lot of confusion about that, especially during COVID times. So always call the court clerk to ask that question. For folks that are facing eviction, you can help gather documentation. So in that, you know, the list of legal defenses to eviction that Anne was talking about, there's documentation that you can help a victim survivor gather and collect that could be helpful for their attorney or for that court proceeding. So that could be things like proof of any kind of payments made, making copies of money orders or checks or things like that can be really helpful. Any copies of utility bills and payments that tenants had made, copies of the lease, and helping the victim survivor read through that and understand what's going on and what that eviction might mean in terms of their lease. If there are police reports, if the tenant was charged for any property damage done by an abuser, that can be really helpful to help them gather, and any relevant photos that they might have. And getting these documents printed and collected and all of that can be super helpful. And then connecting them up with an attorney can be super great. Like Anne has lots of information about how to best proceed, and having them review things like service and all of those good things. And then as an advocate, I will always say, help folks get connected with financial resources as soon as possible. So if someone is facing eviction, I know right now eviction for non-payment of rent is not something that we're thinking about, but I think that getting them connected to any financial resources or any other community-based programs that could be helpful for them going forward, that can really help people not only be set up for success, but talk about the work that they're doing to stay safe and stably housed. Anything to add to that, Anne?
Nope, I think you covered it.
All right.
So the big thing I'm going to talk about today regarding the eviction hearing is settlement agreements. But before we do that, let's talk about what to do if a tenant is being evicted for non-payment of rent and they're not able to come up with that money to get caught up, and the landlord doesn't want a settlement agreement. In Minnesota, over 90% of the evictions, well, this is pre-COVID, over 90% of the evictions are for non-payment of rent. So this issue it comes up a lot. So just by way of context, when a court orders an eviction, they do two things. They issue the eviction order and they issue a writ of recovery. The writ of recovery is, it's the document that goes from the court to the sheriff, and it instructs the sheriff to go to the property to remove the tenant from the property. So the writ of recovery and when that gets issued is a big, is a big deal. The court has discretion to hold that writ for up to 7 days when there's a compelling reason to do so. But the key here is that the tenant often has to request it from the court. Not all courts, I think most courts probably do not do that automatically. So I tell the tenants to say, if they're going into their hearing, you say, yes, I'm behind on rent. No, I do not have the money to get caught up. Please give me as much time as possible to move out because, and then have them explain their compelling reason. Some examples of a compelling reason could be they have kids at home. I know in Hennepin and Ramsey County, if there are kids at home, the court will almost automatically give the full 7 days. The compelling reason might be that the tenant has health problems or mobility issues, so they need help moving their belongings. So then they would want to explain that to the court, to ask the court for that extra time. Maybe the tenant runs the risk of losing their job if they have to miss work in order to move, so they need more time. But again, the court has discretion to hold that writ, but that they can only hold it for up to 7 days. Even if they wanted to hold it for longer than 7 days, the statute does not allow for that to happen. If the judge does hold the writ, the time between that initial appearance hearing and when that writ is ultimately issued is a redemption period. And the redemption period is when, if the tenant can come up with all of that money that's owed, so this includes overdue rent, any other fees, it'll include the court fees, it'll include everything. If they can come up with that before that writ gets issued, so even after the eviction has been ordered, but before the writ gets issued, then the landlord has to accept it and the tenant gets to stay. So that's what the redemption period is. We call it pay and stay. This redemption period is a good place for advocacy to help out because sometimes, especially now, there are a lot of organizations out there that are helping people get caught up on rent. So, this is a place where advocacy can maybe help tenants, keep their housing. The one thing to keep in mind here, though, is that it has to be the actual money. So a landlord doesn't have to accept an agency guarantee during this redemption period, but they do have to accept, if you can actually have the payment in full. So very often at the initial appearance hearing, the judge or referee will order the parties to attempt to settle their case. Most eviction cases end with a settlement agreement. Many courts have their own settlement agreement form for the parties to use. We at Standpoint have created a settlement agreement form that includes more of the terms that we like to see for tenants. So if you're working with people who will be going to court for an eviction, feel free to contact us and we'll give you a copy of our settlement agreement form. What we'd really like for tenants to know is that they can try to negotiate for more than just a payment plan in these settlement agreements. Tenants can also negotiate for expungement provisions, for a caption change, move out dates, repairs, other issues that they're dealing with their rental. So today, though, we're going to focus on the payment plan, the expungement provisions, and the caption change.
All right, so if someone is negotiating a payment plan as a part of that settlement agreement, there are a couple of things to keep in mind. First and foremost, we'll say this a million times probably, that any late or partial payments will be accepted by the landlord and the tenant will be in violation of that settlement agreement. So the settlement agreement in this scenario is a legal payment plan. It's a court order and it has to be complied with. So in that payment plan, you want to have any specific payment amount, and that's going to include, like Ann said, all of the court fees, back owed rent, and all of the other charges. And with that, you also want to make sure that the date and time that money is due is very, very clear. And as advocates, that's where we can be really, really helpful. So trying to get extra time built into that payment plan can be great. So if someone gets paid on a Wednesday, maybe seeing if we could have the payment plan through Friday, so that there's some time just in case something is happening. So there's a little bit of wiggle room there, because we want to make sure that we are on time and on the right date. So that is super important. And the payment must be exactly as it's listed in the payment plan. And like Anne mentioned, I wanted to talk a little bit about agency guarantee versus agency funds. So the payment plan will specifically list the method of, or should specifically list the method of payment. And if you can get the word agency guarantee into that payment plan, that can be super helpful. Oftentimes, especially with a lot of agencies having staff work from home, getting actual money and agency funds can be a little bit trickier these days. And oftentimes agencies are really accustomed to writing a letter saying, hey, landlord, we're going to pay you $500. Here's our letter of guarantee. So some landlords aren't able to accept that, and if it's not in the payment plan, then that doesn't work. And if they only have an agency guarantee and not the actual money, that would still be a violation of the settlement agreement. So advocacy can be really, really helpful to push agencies to reach out to agencies and let them know that we need actual money, and they can also help try and make sure that that phrase agency guarantee is in the payment plan. And then just making sure that the victim, survivor, or the tenant that you're working with knows how the payment's going to be made and exchanged. Is it going to be dropped off? Is it going to be through an online tenant portal? What is happening there, and how is that happening? Just to make sure that there is no question or doubt in anyone's mind that that money has been paid and received by the appropriate date and time and made in the appropriate ways.
So let's talk about expungement provisions. In my opinion, one of the most important things we can get for a tenant in a settlement agreement is an expungement provision. So since we know eviction records remain on the tenant's record indefinitely, and we know an eviction record is a major barrier for people in obtaining safe and stable housing, including an expungement provision in their settlement agreement is one way that we can help victim survivors who are going through an eviction now be set up for success in their future housing searches. There are three main types of expungement provisions that I'm going to talk about today: the automatic expungement, affidavit of compliance, and when the plaintiff agrees that they will not oppose a motion. In the next few slides, I've included the exact language that I use in settlement agreements. So with this PowerPoint, you guys will have the exact language that you can use when working with victim survivors who are going through that eviction process. With the automatic expungement provision, the parties are agreeing that if the tenant complies with all the terms in the agreement, then the court will automatically expunge the eviction record. If the tenant doesn't comply with the settlement agreement, the landlord then will have that option of filing an affidavit of non-compliance with the court, and then the expungement will not be expunged. So for these, you have the agreement, you have the settlement agreement. The settlement agreement will have a date by which when the court can then evict or expunge that eviction. If the landlord has not filed an affidavit of compliance before that date, then the court will go ahead and expunge the record. So for an automatic expungement, I simply write on the agreement form that the parties jointly request the court immediately expunge this case without further hearing by, and then you enter that date, unless an affidavit of non-compliance of the settlement agreement is filed. So for the date, I usually go 30 or 60 days out from when the settlement agreement is completed. So for example, if we went to court today and there was a settlement agreement with a payment plan that ended maybe December 15th, then I would go out to January 15th or February 15th for the date in this phrase. And that extra time is what gives the landlord time to file the affidavit of non-compliance if needed. So, and the date is that you put here would be something that gets negotiated with the landlord, you know, that's something you talk through with the landlord, and you know, finding a date that the landlord will feel most comfortable with. When we talk about an affidavit of compliance expungement provision, what we're saying here is that either the landlord or the tenant will file an affidavit of compliance with the court. So just to back up, an affidavit is a sworn statement to the court, but it's in writing. So when we talk about an affidavit of compliance, what that is a written sworn statement to the court saying, we had the settlement agreement and I complied with all of the terms in the settlement agreement. So either the landlord or the tenant will file the affidavit of compliance with the court, and then the court will expunge the record. So one thing to talk about with this and to think about is which party will file the affidavit. And this is something that gets negotiated with the landlord. Sometimes the landlord wants to be the one to file because it allows them just a little bit more control. But sometimes the landlord doesn't want the extra work. So again, this is just something that the tenant has to work out with the landlord at that initial appearance hearing to try to get that settlement agreement. When it's the landlord who's going to be filing the affidavit of compliance, this benefits the tenant because there's no additional fees for the tenant, and the tenant doesn't have to figure out how to file the affidavit. But when the landlord is the one that files, it can sometimes be a challenge for the tenant to get the landlord to follow through. So if the landlord does not follow through, then the tenant's going to have to file an eviction expungement motion to have that record expunged. When it's the tenant that's going to be filing the affidavit of compliance, this can benefit the tenant because that tenant, kind of has more control over it. But so one thing to think about is that this affidavit is often considered the first filing in the case for the tenant, which means the tenant would have to pay the first filing fee, which is around $280. The tenant can request a fee waiver, but again, that's more work, and that fee waiver is not necessarily guaranteed. The language that I use in a settlement agreement for this provision is that the parties jointly request this case be immediately expunged without further hearing upon plaintiff or the defendant. You'd have to fill in which one. So upon the plaintiff or the defendant filing an affidavit of compliance. So moving on to when the landlord will agree to not oppose a motion. The language is weird around this, but that's how we say it. With this expungement provision, the landlord is agreeing that if the tenant fully complies with the settlement agreement, they will not oppose a motion for expungement down the road. This is the least convenient provision for the tenant because they have to go through that court process of filing an expungement motion and attending the hearing. Even though to some, this seems like more of a hassle, and maybe it doesn't seem like it has a lot of value. It actually does. It's still a valuable provision to have, and it can go a long way in ultimately getting that record expunged. I will say, though, that this is my fallback. So when I can't convince a landlord or landlord attorney to agree on the automatic expungement or the affidavit of compliance, then I'll say, okay, fine. Will you at least agree to not oppose a motion later on? And a lot of times they'll say yes. For this provision, I simply write plaintiff will not oppose expungement if the defendant complies with this agreement. As an alternative to expungement provisions, sometimes it's an alternative, sometimes we add it. In cases where, especially in cases where the settlement agreement includes a move-out date, amending the caption is a good option. With this option, the parties agree to change the tenant's name to Jane or John Doe or something like that. When we choose this option, it's important to specify that not only the caption is changing, but the MNCIS party search index also needs to be changed. So that MNCIS party search index is the database for how people can go and search court records. If the landlord is hesitant on this, you can always include language that says that the caption will revert to the original names if the landlord files an affidavit of non-compliance. The benefits for this really are when the tenant has to move quickly. And so if that eviction is on the record and they go to try and apply for a new apartment and the apartment the landlord, you know, maybe does a quick search of the court records, they can put that tenant's name in and this eviction won't show up. So it can be helpful in that. The eviction record is still there. So expungement is better, but this can still be helpful. And it's important too to remember that the tenant screening agencies still might have the record with the accurate or the original name that listed on the caption, because that court or the eviction record exists for a couple weeks between when the case is filed and when that initial appearance is held. And we know a lot of these tenant screening agencies check eviction records daily. And so if a tenant screening agency checks the eviction, finds the eviction record, it gets put into their database, you know, before we have a chance to amend the caption. So it can still be out there. So it's not foolproof, but it was just kind of one extra thing that might be helpful for tenants. So here we have an example of a caption just for people who don't know what I'm talking about when I say caption. Every court filing, they have a caption like this, and this caption remains the same throughout the life of the case. So for this caption change provision, the court changes that tenant's name right there on the court documents, and it changes on the docket and everything listed with the court too.
All right. So there's lots to talk about with advocacy at this point. So first and foremost, I'll say it again, call the court clerk to verify the date and time and how someone should be showing up, whether things are in person or over Zoom. And then having that conversation with a victim survivor about how that's going to work in their world. Do they have access to the internet? Do they have transportation to get to the courthouse? What does that look like? And having really good conversation and setting them up for that. And then doing regular court prep. Most advocates are pretty familiar with, you know, kind of courtroom etiquette, dressing for court. I know a lot of times we're at home and we are maybe not fully dressed or dressed the way that we normally would be, but making sure that people are appearing ready to talk about business stuff and show up in court in the right way. Again, gathering documentation about any of those payments made and copies of the lease and all of that can be super helpful. And then just to kind of follow up on some of the other things that Anne was talking about, talking with the victim survivor about that extra time before the writ is issued. So thinking through what a compelling reason might be to give them that extra, hopefully 7 days to move out. And what does that look like? One, can they get that 7 days? And two, what does safety look like during that time frame while they're moving out? You can consider writing a script for that so that the victim survivor is prepared and ready to talk that through. I think it's important to know about these different expungement provisions and the different options that are available. And of course, it has to be negotiated and agreed upon, but simply knowing that there are different options available for someone rather than just having to leave their house can be really helpful. So talking those different things through and explaining some of the options to the victim survivor, and then calling a landlord attorney, or excuse me, a tenant attorney like Anne, housing attorney, to talk that through and see what might be the best fit can be super helpful. We also have that settlement agreement form, so you're welcome to reach out to us to talk that through and look that over. Can be super helpful. And then to go to court with someone, if and when and however we're able to do that, can be really great. Because as we know, court is overwhelming and traumatic sometimes and kind of scary and intimidating. So if we're able to be that presence with someone, that can be super helpful. And then we can also help talk with the landlord to help negotiate that settlement agreement. And that can be super helpful. And then again, the biggest piece is to remember the difference between agency guarantee and agency funds. And that will kind of help drive you as an advocate in helping someone get the funding available or get the resources and financial assistance available in a quick manner so that you know for sure that the funding is going to be available to the landlord per the settlement agreement. And then finally, I think that's all I got actually, just kidding. Anne, anything else to add?
Yeah, I was just thinking when you talked about funding, remember that right now there's a lot of COVID funding out there for people who've fallen behind on their rent or mortgage payments because maybe, you know, because of COVID in some way, whether they lost their job or maybe they had to stop working for a few weeks and then they fell behind. So if you're working with people, you know, it's worth bringing it up with people like, hey, how are you doing on your rent? And so, because if people are behind, there's money out there for that at this point in time. And if you have questions about that, you can give us a call. We can help direct you to the right places. Okay, so we're going to say it again. When there's a settlement agreement for an eviction, it becomes a court order. So remember, later partial payments, they can be accepted. They will be accepted. The landlord will take the money, but the landlord can still turn around and file an affidavit of non-compliance. I've seen it happen. It's extremely frustrating because the landlord still has what they got. They just got it a little bit later, you know. But legally, it is a violation of that settlement agreement, and it can end up interfering with the eviction being expunged. One thing to think about here, sometimes if the tenant has a payment plan made through the settlement agreement and now it's a court order, if the tenant knows that payment is going to be late, they can call that landlord and say, I know we have the settlement agreement. I'll have the money. I'm going to be like a day late. Is that okay? If the landlord says yes, then you'd want to make sure that you kind of have that in writing so you can prove it. Then you probably would be okay. The tenant would be okay making that late payment because the tenant is relying on the landlord's, you know, approval of that arrangement. It's still risky. If there's nothing in writing to prove it, then I definitely advise against it. But it is kind of one way that, you know, people can work out if they fall behind again with their payments and their payment plan. And then once the eviction hearing is done, there's still work to do. So the tenant will have a settlement agreement, and of course they have to follow the payment plan. But what does that settlement agreement say? Did we get the expungement provision? And if we did, which one is it? Do we need to file an affidavit of compliance, or do we need to follow up with an expungement motion? If it's an automatic expungement, then the tenant needs to keep going back looking at MNCIS to make sure that eviction record eventually drops off of the court records. So there's a lot to do after the hearing as well. And this is like one of the most important things that I tell people is keep copies of the paperwork. So if you have an expungement provision that is written into a settlement agreement, or if you end up filing an expungement motion and the tenant ends up with an expungement order, we need to keep copies of that because the court documents will go away and the tenant will definitely need to prove that eviction was expunged at some time in the future. And like not having that eviction record appear in a court search is not proof of expungement. So I tell the people that I work with to take pictures of either the settlement agreement or the expungement order, you know, wherever the language is that shows that the eviction record is going to be expunged. Take pictures of it, email it to yourself, you know, make hard copies, give a copy to your mom, give a copy to your friend, do a lot of different ways of saving that documentation so that, you know, 5 years from now, if the tenant is going to try to get a new apartment and this eviction pops up in a tenant screening report, the tenant is going to be able to find that documentation and have that tenant screening agency remove it from their database. It's really, really important.
Oh, there we go. All right. So a lot of the things that Anne just talked about are really great ways for advocates to provide guidance and assistance and help victim survivors through that process. So keeping copies, we're pretty familiar with doing that with things like orders for protection and harassment restraining orders. So yes, keep copies all the time in all the different and creative ways that Anne mentioned, or the other ideas that you have that can be super helpful. You can also mail copies of eviction expungement information to the tenant screening agencies. and that can be really helpful. There are like a million of them, so we might not get them all sometimes, but that can be really helpful to get so that the tenant screening agencies are up to date and have up-to-date information. Advocates can help with that affidavit as well, and that can be super important. And then the biggest piece is helping folks follow the settlement agreement, whatever that looks like. So following up with any payments that need to be made, anything along those lines can be really, really helpful with an advocate to kind of walk alongside. And then also advocates can help by checking MNCIS to see if that eviction expungement has been, or the eviction, excuse me, has been removed, so that court record is no longer popping up. And that can be easier for advocates to remember to do oftentimes, so that can be helpful. And then again, just keep all those copies of all of the eviction expungement information and settlement agreements and anything else that we need to from that court hearing. And I think as an advocate, when I think about kind of what we've just talked through in terms of eviction and expungement and those sorts of things, we know that housing is safety. We have really unique and important relationships that we've built with the victim survivors or the tenants that we're working with. And I think that having an advocate walk alongside someone through that process can be really, really helpful. The eviction process can be, again, scary and traumatic, but an advocate walking alongside you can help you think long term. So yes, if someone is being evicted, they need to know where they're going to live right away. That's where everyone's brain goes. Where am I going to stay? Where are my kids going to stay? You know, what does that look like for me? But an advocate can help with that immediate need and help set people up for success down the line. So they can think about these, the different kinds of expungement or the provisions that they can get into that for people. And that really helps set people up for future housing, because we all want people to gain and maintain safe and stable housing, right? We know that housing is safety, and it's huge. Has a huge impact on people. Their safety and their well-being depends on having somewhere safe to stay. So I think that as advocates are able to walk alongside someone and know about these different expungement provisions and really get active and involved in housing advocacy and attending housing courts and learning more about these things can be so helpful in the long-term kind of safety for victim survivors. And I think that wraps it up for us. So does anyone have any questions, thoughts, concerns, or anything else we can answer before we head out for the day? I don't think so. I don't see any, at least. So Anne and I will stick around for a little bit, but thank you all so much for joining us. We're glad that we could kind of talk a little bit about evictions and expungements and what that looks like for people. We're hopeful that this information is helpful for yourself and for those that you work with, and know that you're always welcome to reach out to myself and Anne with any other questions or concerns that you have going forward.
Thanks everyone for coming out today. Thank you again to Anne and Raelene. And if there are no further questions, which I don't see anything coming through, I will then end the webinar.